And
well, I'm sorry, you don't think we should have an operating definition of sex in Title IX? Now, I understand the idea that well, the question then becomes not whether or not there's discrimination on the basis of sex, but whether there's discrimination on the basis of whatever characteristic you think should be included in the definition of sex. Now, when it's used as a statutory term, I'm not sure you have that kind of flexibility. The question would be instead, what does Congress think the word means?
Well, Your Honor, I guess I'd say I think Congress prohibited discrimination based on sex. I don't think.
I'm sorry, go ahead.
Yeah, and so I don't think that, just as I don't think Congress adopted a definition of race, in Title VI in order to prohibit discrimination on the basis of race. I think I'm not trying to police the accuracy of the terminology that's being used. All I'm saying is that what's being prohibited is using this classification to discriminate, not.
So well, but without really knowing what the distinction is.
Well, I don't think the examples I've given about sex-based characteristics fall outside the common understanding of things that are related to sex.
Well, related to sex. I guess what you're saying is then we do have to accept for your position that we're not dealing when Congress says sex, we're not dealing with biological sex. But we're dealing with other characteristics that people might associate with sex?
No. I think for this case, you can accept for the sake of this case that we're talking about what they've termed to be biological sex. I think that resolves this case. I was just talking about in addressing other potential cases.
So we don't have to say anything about the matter. You're willing for us to proceed on that assumption.
Exactly. Just like in Bostock, I think you can proceed for argument's sake. Without taking a definitive position here, because it might have downstream consequences in other cases that even the United States doesn't want the court to prejudge here. Now, I would like to say one quick thing on Justice Barrett's reference to separate classrooms. I mean, it is true, and the ACLU's litigated cases about theories that there's different brain sexes for women versus boys, and that's why you need separate classrooms. I think the instinct was completely correct that you can have a lot of scientific justifications for discrimination. That doesn't mean that the discrimination is allowed or immune from scrutiny. And in fact, some of the studies that are cited in the amicus brief say boys are naturally more aggressive, right, and favor competition more because that's in their DNA. So I do think even in these studies, the idea that you're completely, just basing it on pure biology and not on other generalizations doesn't quite hold up. I'd also, to the extent that we want to go back to Caban, I do want to just make a couple quick things clear. Caban was not a facial challenge. It wasn't. And neither was some of the First Amendment cases they were talking about weren't equal protection First Amendment cases. They were commercial speech cases. Michael M. also wasn't a facial challenge. He wasn't saying I should have an exception because a prepubertal girl was involved. He was saying the statute is overbroad because in theory it could apply to a prepubertal girl. So I do think that some of the characterization of the cases doesn't hold up to our reading of them.
So how does